Sheetz versus County of El Dorado, California, 2023. As a condition of George Sheetz developing a property, he was required to pay $23,420 traffic impact fee because of the rate schedule at the time of development. Sheetz argues that this fee was unconstitutional because it is an individualized fee based on offsetting the cost of traffic congestion that will be caused by the project. The takings clause does not distinguish between legislative and administrative land use permit conditions. The Fifth Amendment allows eminent domain, which is government taking private property for public use. The takings clause means that when the property is taken for public use, the public must pay the burden of taking/using said property. The government can deny a permit unless there is a legitimate police power purpose. When the government withholds a permit for unrelated land use interests, then it is extortion. Permits must be essential to the government's land use. Permits conditions must be proportional to the development's impact on land use interest. Conditions on the building permits can be questioned and challenged. These challenges are with the state courts. This was a 9-0 decision. Barrett delivered the opinion. Sheetz wanted to build a small prefabricated home, but he had to pay a substantial traffic impact fee to mitigate local traffic. The lower court dismissed this case because the traffic impact fee was imposed by the legislation. The takings clause doesn't distinguish from legislative and administrative permit conditions. The state courts rejected the claim, and the Court of Appeal and the Supreme Court denied review. The Constitution does not limit the takings clause to a particular branch of government. The fees are allowed to be reviewed by the court. A state court should review the permit fees. Sotomayor had a concurrent opinion with Jackson. Building permits can be scrutinized by the court. Property right protections are in the hands of legislators and administrators. The taking clause applies to both equally. So legislatures and administrators should not be able to impose unconstitutional conditions on land use permits. The lower court, California State of Appeals, should review the case. Gorsuch filed a concurrent opinion. If the takings clause is just like all other constitutional rights within the Bill of Rights, then all of the other constitutional rules apply. Kavanaugh filed a concurrent opinion with Kagan and Jackson. The decision does not address or prohibit impact fees and other government actions that imposes permit conditions. These permits are imposed based on reasonable formulas.